Earlier this week, on the gloomy dawn on November 8, 2015, Robbie, the boss of the famous local fishery aquaculture, was accompanied by her helper, Nika, near the riverbank of Gabu, Lawag, Ilocos Norte. According to the locals in the village, Robbie is commonly seen to oppress her helper through making her catch fish using her bare hands and transport it with bare feet in the rocky roads of the village. On the other hand, it was told that the reason Nika's boss is oppressing her is because of Nika's inefficiency in doing her job. And she complains too much to the extent that other villagers can hear complaints about her boss. And that evening, Nika had enough. She threw away her daily catch of fish and went on an outrage, confronting Robbie with the ball on her arm with his threat to kill her, saying that she was not given preference of her labor, nor any amount of labor to suffice her tedious job. Nika pointed out that she has bruises all over her hands and feet, which caused her to complain about her boss. This confrontation made Robbie defensive, which made her to grab her bolo to stab Nika, chasing her away. But Robbie outspeed Nika, causing her to stab the helper in the abdomen, penetrating the object 15 inches long across her body, scarring her liver, which made the poor helper scream so loud that it caught the attention of nearby people. This caused the nearby localities to call the police and reprimand Robbie for her violent behavior and brought Nika to the Ilocos Norte Provincial Hospital. Luckily, Nika survived her wounds because of the immediate medical procedure. The doctor declared that were it not for the timely medical assistance, the victim would have died of hemorrhage caused by the fatal stab wound that penetrated her liver. That might have caused her death. Discharged from the hospital on November 21, 2019, the complainant had to return twice for the continuation of her treatment. She was incapacitated for pursuing his calling up to March 2020. According to the reports, the incident happened around 9 in the evening, where most villagers are already asleep. However, a local informed the team that she had heard Nika screaming, "Baka, mapatay na kita," which caused the screaming and the loud chasing from the. It was said that because of Robbie's threat, it caused Nika to charge violently against Rob.
In view of the criminal case number 17629, filed by the people of the Philippines, filed in the Regional Trial Court of Ilocos Norte on January 31, 2019, against defendant Robbie Harim, charged with frustrated homicide, is hereby found guilty thereof, with the execution of the crime during nighttime as its aggravating circumstance, offset by the defendant's voluntary surrender as its mitigating circumstance. The court, in the exercise of its discretion, impose an indeterminate corporal penalty lowered by 1 degree ranging from 3 years, 5 months, and 15 days of prison correctional as its minimum, to 8 years, 11 months, and 15 days of prison mayor in its medium period as maximum. It is also ordered the defendants to indemnify the offended party, Nika Coronel, in the sum of 856,000. Defendant's appeal is direct to this court.
The adjudicated decision by the court charging the defendant guilty of frustrated homicide and imposing of the penalty of the said crime, the defendant's lawyer filed a formal notice of his intention to appeal to the Honorable Court the judgment of conviction rendered, seeking conviction for a lesser crime. Thus, we have with us today and will be called on stand the witness of the defendant.
May we have in the court the witness of the crime, if you will speak the truth and only the truth on the incident.
Yes, Your Honor. It was around 9 p.m. when I heard my co-worker Nika having a heated argument with our boss Robbie Haring near the riverbanks in Gabulawag, Ilocos Norte. And I can still remember Nika shouting towards my boss or our boss, Robbie Haring, saying the line, "Baka mapatay na kita," and this action was subsequently followed by the action of Nika grabbing her bolo, only for our boss to defensively react by doing the same, and this resulted to the situation where our boss stabbed Nika. And with regard to my experience with my boss and in my work, I never experienced any violence from my boss, nor she forced me to do my work from my 10 years of experience.
So I appealed to the Court of Appeals, invoking self-defense and sufficient provocation from the offended party as additional mitigating circumstances, and sought for the reduction of the penalty imposed on me. I also took the position to apply for probation in case the court metes out a new probationable penalty.
Before the appeal, my client cannot be entitled to the application of probation because she was sentenced with prisión mayor in its medium period, a non-probationable penalty. However, while waiting for the judgment of her appeal, she is still impermissible to simultaneously apply for probation, as the same could only be entertained once she had already perfected her appeal from the judgment of conviction. We hope that the court hears our plea for the lowering of her sentence so she can apply for probation.
So the accused filed for application of probation within 15 days before the rendition of judgment within the period of perfecting an appeal.
The court hereby modifies the decision dated January 31, 2019 of the Regional Trial Court of Ilocos Norte and finds petitioner Robbie Haring guilty beyond reasonable doubt of frustrated homicide with the presence of two mitigating circumstances from Article 13, Section 1 and 4, such that the defendant acted in self-defense with sufficient provocation, and the plaintiff's sufficient provocation which immediately preceded the act. The court, in the exercise of its discretion, now modifies the imposed sentence to a lower indeterminate corporal penalty, ranging from 5 months and 15 days of arresto mayor in its maximum period as minimum, 3 years, 6 months, and 15 days of prisión correccional in its medium period as maximum. This is without prejudice to the petitioner's application for probation within 15 days from notice that the record of the case has been remanded for the execution to the Regional Trial Court.
The accused appeared in the probation office where we required her to submit a post-sentence investigation worksheet and further interviewed based on the information contained therein. The antecedents, mental and physical condition, character, socio-economic status, criminal records of the applicant, and the institutional and community resources available for her rehabilitation have also been thoroughly examined. The applicant possesses no other criminal records, which has also been verified with the proper government agencies. Collateral information have also been gathered from those persons who have direct personal knowledge of the applicant and the offended party. It was shown that the applicant worked for the company for about 10 years without any prior misconduct, as opposed to the contention of the witness that Robbie was commonly known to oppress her employees. It has been found that there are no discrepancies between the information received from the applicant and those secured from other sources. I strongly recommend the granting of the application for probation with a period that shall not exceed 6 years pursuant to Section 14 of Presidential Decree No. 968. The offender is not also within the disqualification set out by the same law. The application for probation was also filed within the period allowed by law, pursuant to Section 4 of Presidential Decree No. 968 as amended by Republic Act No. 10701. It is a general rule that the filing of an appeal and the perfection of the same would result in a bar for the application of probation. In this case, however, the Regional Trial Court had modified the non-probationable penalty to a probationable penalty. The accused manifested that she was only appealing for the purpose of correcting a wrong penalty, to reduce it within the probationable range, meaning to say that the decision of the court had not yet attained with finality. Hence, an appeal therefrom was possible under the law, and Robbie is now qualified under the application for probation.
The judge will issue an order to the probation officer to conduct a post-sentence investigation, which upon no later than 60 days should submit the same from receipt of the order of said court. Upon evaluation of the post-sentence investigation report rendered by the probation officer, the court has found merit in the offender's application for probation. The contention of the defense that the petitioner is barred from the grant of probation is untenable. Ordinarily, Robbie would no longer be entitled to apply for probation, having appealed from the judgment of the RTC convicting him from frustrated homicide. However, the court found Robbie guilty only of arresto mayor, and with this new penalty, it would be fair to allow him the right to apply for probation upon remanding the case to the regional trial court. Wherefore, the court finds the petition upon the post-investigation report with merit and imposes a period of probation that shall not exceed 6 years. The following conditions of the probation order are set out as follows. Under the mandatory conditions, to present himself to the probation officer concerned for supervisions within 72 hours from receipts of said order, and to report to the probation officer at least once a month during the period of probation. And under the discretionary conditions, the offender shall refrain from visiting houses of ill repute, and the offender shall devote herself to specific employment and not to change such employment without prior written approval. After the period of probation, and upon consideration of the report and recommendation of the probation officer, the court may order the final discharge of the probationer upon finding that he has fulfilled the terms and conditions of probation, and thereupon his case is deemed terminated.
And that wraps up the case of People versus Haring, the criminal case number 17629. This is your host, Attorney Arvin.
And this is Attorney Tracy, and we are back here at Crime and Chill podcast to answer what if questions regarding the previous case we just tackled.
Again, this is Crime and Chill, the podcast that answers your doubt and never for clout.
So yun nga, partner. No? Ngayon nakita na natin ng mga viewers natin itong case ni People versus Haring. No? Sasagot naman tayo ng mga feasible legal scenarios na possible na magkaroon ng pagbabago para sa mga penalty na naka-impose kay Defendant Haring.
Now, for your questions, pwede niyong gamitin ang ating official hashtag #AskAttorney in our official social media accounts, at Crime and Chill on Twitter and Facebook. Now, sige, mag-ask lang kayo. Ayan. So,
Dami ng questions.
dami ng questions. So, for our first question from, si Attorney OCJ from Manila!
Si Attorney RCJ.
Grabe guys, ito yung naging crim law prof namin nung pre-law course pa lang.
Hello po, Attorney. Ngayon po, nakapasa na po kami ng bar. So, ang question niya po is that, what if hindi sumuko agad ang accused and it took him how many years before he was arrested?
Grabe, quite an interesting question nga from our netizen. So, ano sa tingin mo, Attorney Arvin?
In this case kasi, it will depend upon the circumstance. No? So, para sa ating mga listeners, this falls under the prescription of crimes sa ating revised penal code wherein the state states na if the state basically loses its right to prosecute the offender due to the certain lapse of time. So, ano nga bang ibig sabihin ng prescription of crimes? No? This only means na pag naglapse na yung certain penalty imposed ng law ng isang crime, hindi na pwedeng isakdal ng Estado ang nakasala o ang akusado. At kailan nga ba nagpe-prescribe ang isang crime based sa Article 19 ng Revised Penal Code? Ayan, papakita lang natin sa screen yung mga prescription crimes based sa Article 19. So, in the case of People versus Philippines versus Haring, kung saan ang crime ay frustrated homicide under the RPC, the penalty for such is 1 degree lower penalty ng homicide. This means that the penalty imposed by the law is prison mayor. Mag-prescribe lang siya ng 15 years. No? But take note to our listeners, we should also ask, kailan nga ba mag-start ang computation ng prescription?
So, Attorney Arvin, kailan nga ba?
Basically, under Article 91, there are two instances na nag-determine ng computation ng prescription ng ating crimes. Una, if known, may it be the offender, authorities, or their agents, the period of prescription will commence from the commission of crime. Secondly, if unknown naman siya, the period prescription will commence from the time of discovery, either by the offended party, the authorities, or yung agent ng authorities.
Ayan. So, I hope mas naliwanagan kayo kahit papano, no, partner?
Oo nga, partner. Ngayon, hindi dyan nagtatapos ang programa ito. We'll read more questions from you to have a better understanding. Siyempre, lahat naman tayo dito curious kung ano nga bang nangyayari sa isang kasong tulad nito.
Okay. Now, for our second question, oh my gosh, kilala namin to ni Arvin yung nagtanong. So, for our second netizen na nagtanong, si Miss Trisha Chandumal.
Kasi natin dati.
So, ang tanong niya is, attorney, what if naman po, hindi siya nag-grant ng probation? Tapos, while serving his sentence, tumakas bigla yung accused. Tapos nahuli after 20 years pa.
Very interesting question. So, in this case, papasok natin yung prescription of penalty.
Ayan. Ano nga ba ang prescription of penalty? Para sa kaalaman ng lahat, prescription of penalty means loss or forfeiture of the right of the government to execute the final sentence after the lapse of a certain time. Sa madaling salita, kapag lumagpas na or nagkaroon na ng lapse sa given time, depende sa penalty, ay mawawalan na ng karapatan ang gobyerno na hulihin pa ang defendant.
Tama yun, no, Attorney Tracy. Kasi dahil sa pagkakaraan lamang ng 20 years, nung natagpuan muli siya at hinuli, they now have the right to petition for habeas corpus, contending that the penalty has already been prescribed and therefore can no longer be imprisoned.
Yes.
So, under the topic naman ng extinction of criminal liability, mukhang magiging magandang discussion natin today because these questions from our listeners are just getting more interesting as we go on. So, for our next question, and here is our listener in Mindanao, no? Mukhang nationwide na talaga ang nagiging podcast natin for today's video. So, here, his question was, from Kevin Capto siya. I think naging classmate natin ito nung sa pre-law course pa lang tayo. He asked, attorney, what will happen po if during the ongoing case, the convict actually dies?
Ayan, so, bago ko sagutin yan, gusto ko lang mag-hello sa 5,000 viewers natin, no? Napakarami.
Dahil viewers.
Ang daming gustong matuto. Ayan. So, going back, of course, that would fall under the first paragraph of Article 89 of our revised penal code, or the extinction of criminal liability. However, dapat wala pang final judgment or hindi pa ito na-execute prior to the death of the convict.
Oh, no. So, what we're talking about here is criminal liability, di ba? Kailan naman na-extinguish ang civil liability ng isang convict under this scenario?
Of course, just like with criminal liability, it also gets extinguished if the death occurs before the final judgment. Kasi civil liability only exists when the accused is convicted by final judgment. So, since diba, there is no execution of final judgment yet, the right to indemnity is likewise extinguished rin.
Pero wag rin nating kalimutan na just like any other laws, there are also exceptions that falls under this rule. No? And one of that is the civil liability survive, notwithstanding the death of the accused. No? If the same loss may be also predicted on the source of an obligation other than the delict, the example of this obligation that arises from laws, contracts, quasi-contracts, or quasi-delicts.
Yes. Tsaka, alam mo, partner, yung isang magandang example para dyan is yung when one may claim for civil liability arising from offenses of physical injury, di ba? Kasi dahil ang civil action for damages under physical injury is separate and distinct from criminal action that was done by the offender.
That's right. No? Kaya they need to file a separate case specifically intended for a civil action, and the case is not predicated on the felony that was previously charged rather, to the offender, but on the sources of obligation.
Yes. And lastly, para sa topic na to, kailangan let us always keep in mind that the death of the offender, or rather the offended party, does not extinguish the criminal liability of the offender, ha? Because sa criminal cases are committed against the state. Yan.
Oh, that's actually super correct, no? And I'm actually viewing my cell phone right now. And meron ako na-receive na interesting question sa isang netizen natin mula sa Twitter, no? Mukha ata siyang may alter, alter account natin sa Twitter, pangalan. Si
Mabot na tayo sa alter, partner.
Nako, Diyos ko, mga listeners talaga natin kung saan nanggagaling. This is a question from @JeffyLishu69, no? Since nasubaybayan niya ang mga recent criminal cases natin mula sa People versus Haring, no? He asked in a tweet, "Attorney, what if tumakas si Haring after niyang bumalik sa confinement to serve for her original sentence since na-violate niya yung probation requirements niya, no? Is she still entitled for parole even serving her minimum penalty?"
Grabe. Super imaginary facts talaga tong what if na to. Pero, of course, wait lang. Grabe ka, Jeffy Licious 69, ha? Pero, sorry. Pero to answer that question, of course, no. Kasi our defendant cannot apply for parole anymore. Dahil, ayon sa Section 2 ng ating intermediate sentence law, you were disqualified to apply for parole if you escaped from confinement or evaded your sentence.
That's actually correct, no? And for your information lang, no, JeffyLisher69, no, a general rule here is that if ever you have been convicted of a crime, you're also entitled for parole once you have served your minimum sentence, no? So, however, may disqualifications sa ating batas, you're disqualified to your parole if ilalagay siguro natin sa screen yung mga disqualifications for parole para makita ng ating viewers right now. Ayan.
Ayan. Grabe naman talaga imagination nito si Affiliation. Just go for tonight. Di ko partner. Loka
Yes,
ako.
ganyan siguro yung mga wild, mga alter people natin sa natin.
Totoo. Makakabot na tayo ng Twitter. Anyways.
Ayan. Moving on sa next question natin. No? Parang familiar tong name na to. No? Another question from our netizens. No? Ang reyna ng Pulilan, ang winner sa bakbakan. This question was from Miss Bianca Domingo ng Pulilan, Bulacan.
Oh my God. Grabe naman yung reyna ng Pulilan, Mars.
Reyna talaga siya ng bakbakan talaga.
Totoo.
So, her question reads, no, Attorney, paano kung si Robbie ay mayroong 16 informations filed against her in one decision and each of term of imprisonment is 1 year and 1 day? Disqualified na po ba siya from application of probation?
Actually, yung mga ganito, very common mistake talaga to in applying disqualification sa probation law. Bakit? Kasi isa sa general disqualifications natin sa probation law ay those sentenced to serve a maximum term of imprisonment of more than 6 years. Attorney Arvin, ano nga ba yung mangyayari kapag ganito?
Okay. So, hindi siya covered partner, no? Sa kaso ni Francisco versus Court of Appeals, no? Sabi ng Supreme Court na kapag nag-impose ng multiple prison terms ng Korte Suprema sa isang desisyon, hindi dapat yan pag plus, yan 1 plus 1.
Ayan, tama. Kasi the multiple prison terms rendered in one decision should not be added up. Dahil kahit pa pagsamasamahin ng mga prison terms na ito, ito ay sumobra ng 6 years, kung ang individual terms naman ay hindi nag-exceed ng 6 years, hindi disqualified si accused.
Ayan, guys. So, dapat be careful talaga tayo sa pag-apply ng disqualifications, lalo na sa may probation law. Para hindi tayo malito, always apply the landmark case ng Francisco versus Court of Appeals.
Tama. Okay. So, ayan, susunod pang question para sa topic na to. Okay, now, ang sabi naman dito, attorney, papaano po kung mayroon ng probation under under probation order pero hindi nagpakita si probationer kay probation officer, ano po ang mangyayari?
Okay, gets it. Dito kasi, dapat clear yung mga conditions natin, no? And to make things clear, no, may dalawa tayong klaseng conditions. Una ay ang mandatory conditions, which every probation order issued by the court shall contain these conditions. Pangalawa naman ay ang discretionary or additional conditions. I-take account natin ng Court Suprema kung una, ang mga violation ba ng conditions ay serious to justify the warrant. Kapag napatunayan ang violation, the court may issue the probationer's warrant of arrest.
Yes. And of course, an informal and summary hearing will be set out para naman makapag-explain si accused. Syempre, discretion pa rin ng korte kung i-revoke ang grant of probation eh. Kung ang decision ng korte ay bawiin ang probation order, ano ang mangyayari?
Pag ganyang kaso, no, the offender shall serve the penalty imposed of the offense under which he was placed on the probation. Or in other words, balik ka sa unang sentence mo, girl.
Tama, kaya dapat natin tandaan na kapag nagbigay ng condition ang korte, dapat talagang sundan. Bawal pa sa white naman. Diyos ko.
Tama yan. And I think at this point of time, our viewers can actually take in consideration, no, yung napanood nilang kaso compared sa mga ngayong na Q&A answers and portions right now. And I think
Yes.
that in itself actually wraps up our session for today's video. No?
Sa mga ibang hindi namin nasagot na questions, huwag kayong mag-alala. Marami pa tayong podcast na marami pa tayong masasagot na questions dyan.
Yes.
Yeah.
And that basically wraps up this today's episode for Crime and Chill. This was Attorney Arvin.
And once again, I am Attorney Trey. Thank you and susunod ulit.
Thank you, everyone.